Hi, good evening, ladies and gentlemen. Good evening. No response.
Good evening, sir.
Sajini,
Yes.
did you attend the last the last session?
Yes, sir.
Right. What we discussed today is our 5th lesson. Right. So what we discussed?
Wait.
Just look at your note.
Okay, sir. Wait. We have.
Just 1 second.
Sir.
Can anybody tell me what is the main topic and the last note that you have taken?
The last note is Sri Lanka Insurance Corporation
Sorry?
Commission of Labor.
No. Tell me the main topic.
Employment Relationship Contract of Employment Workman Test.
Right. Contract of employment. Okay, right. So, okay, right. The contract of contract of employment. Sorry. Just give me 1 second now. Employment relationship. Oh, just let me share with you. Employment relationship, yes. I hope, this is the one we discussed last week, right? Employment relationship, contract of employment, workman test. Am I correct? Ayodhya?
Yes, sir.
Right. What is the last note? Last, I mean.
Sri Lanka Insurance Corporation Limited versus Commissioner of Labor.
You have, those are, the court decisions. Sri Lanka Insurance Corporation Limited versus Commissioner of Labor. I told you, the motor car assessor, a person was recruited for motor car assessor. His duty was to safeguard. Hey, ladies and gentlemen, I'm telling you, this is not an easy task, easy subject to learn. You have to be very careful. And I'm repeatedly asking everybody, if you don't understand, please let me know. Am I asking or not? Am I giving you a chance to raise question or not? Am I not giving you any chance to raise questions?
You are giving, sir.
Yeah, but unfortunately, right, this is my, the first time in the history. Yesterday, I started another English medium one. Out of 82, around 2-3 people have said that, they don't understand what I said. Maybe they don't understand English. either. Or they are not focusing. So what I am trying to tell you is, you are the customers. If lecture is not delivering or not giving you the proper subject knowledge as you expect, it is, you have freedom to complain to the department or LPEC, and they will find some other lecture. But, I'm giving you a chance to raise questions if you do not understand what I say. Without raising any question, don't complain. Right? I know I'm always thinking, how can I stop this lecture, the delivering these lectures, because I don't have time right now. But anyway, I love to teach. That is why, and I know this subject, A to Z, than anybody else. So I love, and I'm giving you the chance to raise questions and get some clarifications. But if you are silent always, even though you have been given chances to raise questions, some of you are silent and later complain that, right, the lecture is not giving not proper knowledge, right? He is too fast and, we can't understand. So if you don't understand, raise the question. I'm ready to answer. I'm ready to repeatedly explain. But if you are silent, it means that I understand, you have already understood. Okay? So therefore, if you have any question, please raise. Please raise. If you don't understand anything, please raise your hand. Please raise your voice and get it clarified. Okay? Do you understand what I say?
Yes, sir.
Right. So this is the example, ladies and gentlemen. So his duty was inspection, assessment, investigation, and right, he was supposed to be available at short time, and no clause permitting him to delegate his work. So in such cases, if he cannot delegate his work to someone else, if he has to be there anytime as required by the company, then he's not an independent contractor, because he is controlled by his employer. If the worker is controlled by anyhow by the employer, he is not an independent contract, but he is an employee. Okay? Is it clear? Do you understand what I said?
Sir, can you explain it again?
Okay, right. First of all, Suresh, you need to understand this very basic principle. What is that? You and your employer has an agreement, whether it is written or oral or unwritten, whatever it is. There is an agreement when you will be recruited for a job. there is an understanding, no agreement between you and your employer, whether you will be issued a written document, that is the letter of appointment, or not. There is an employer-employee relationship. If there is no employer-employee relationship, we cannot apply the labor law. We cannot apply. So, how do we understand? How do we determine a person X is worker or not? Meaning that he has employment contract, whether he has employment contract with employer or not. There are two aspects in this regard. The working people, they are working sometimes, the majority of them, 99% of them are working on a contract. That is what we mean by employer-employee relationship. Is maybe verbally or written, right? You will be recruited for a job. There is another aspect. Just you will be assigned some task, just you perform as outside. You just perform, not contract of employment, contract for employment. You will be given a certain task. On the basis of fulfillment of that task, you will be paid. Okay? So, there are ambiguities in this regard, right? There are ambiguities in this regard. Ambiguities on what? Employers are trying to manipulate the things, and they say, this man is not my worker, but he just an independent contractor. I assigned some work, he fulfilled that work, and based on the work done, I paid him. I had a contract with him. He's not my worker. If he is not a worker, the employer is not entitled to pay gratuity, compensation, EPF, nothing. So this situation is manipulated by some of the companies. They are actually recruited people, but giving some task and interpret it as employer. There is no employer-employee relationship, but rather contract of employment. In such ambiguities, how do we identify? How do we identify whether this man is an employer or an independent contractor? In order to do so, we use economic reality test, control test, integration test, economic reality test, and mixed method. We have discussed all these things. This is not, what is there in law, but I'm giving this for you, the Sri Lanka Insurance Corporation Limited versus Commissioner General of Labor, to make you understand what do we mean by contract of employment and contract for employment. This is a court case in that regard. If the employer is controlling the job of a worker, if the employer has to sign and, many, the regulation, adhere to many regulations, then the title may be, the title given to worker may be independent contractor. But we have to go into details and understand whether this man is really a contract, working on contract for service or contract of service. If it is contract for service, definitely he is not a worker, sorry. But in some cases, there are ambiguities. So we have to settle that ambiguities. In that context, we use, as I already explained to you, the control test, integration test, economic reality test, and mixed method. Is it clear to you right now or not?
It's clear, sir.
Right. Now, Reverend Father Alexis Benedict, that is also the same, right? I'm not going into. And then let me discuss with you another court decision. Hatton National Bank Limited versus Commission of Labor. HNB Bank, Candy branch of the bank, entered into a service agreement with a person in 2002. The agreement was to provide electrical maintenance. This is an agreement. It's a kind of a contract for employment, not contract of, right? සේවය සඳහා බඳවා ගැනීම නෙමෙයි යම් කාර්යයක් බාර දෙනවා. The agreement was to provide electrical maintenance during the day from 8 a.m. to 5 p.m. for the consideration of rupees 6,500 at that time, payable by the bank at the end of each month. The bank thereafter entered into a revised agreement in 2005 with Susant Electricals, represented by the same person, to render the said service. The bank said the title was independent contract. Bank put the title that is independent contract to avoid the payment of EPF, PTF, gratuity, all these things. But the bank controlled the work of this man. How? The bank required the workman to sign the attendance and register. If you are supposed to sign the attender, it means that you are a worker, not an independent contractor. If an independent contractor, you come, as you wish, you perform the task. Whether you come or not, it is none of the business of the employer. You have been assigned a task. The money is given based on the fulfillment of task. So you are free to come at any time and supervise everything. But in this case, he was supposed to sign, right, the attendance register. It means that employee is controlling this man. So if you are controlling your employee, how could you say that he is an independent contractor? It is not possible. So finally, it went to the Court of Appeal. The court held that Susant Electrical, this person was a workman. Okay? Is it clear? Do you want me to explain further? Lumbini, is it clear?
Yes, sir.
So I can't hear. Is there anything else? Is there anyone who could not understand? Please let me know. If not, I'm leaving to right. Another slide, that is thank you for your active participation. So tell me the main topics that we have discussed so far. Tell me the main topics. First one was introduction to industrial relation. Am I correct? Tell me.
Yes, sir.
Right. What was the second one? What was the social dialogue? Am I correct?
Yes, sir.
Number 3, employment relationship. That is, that's what we discuss right now. Okay. Am I correct?
Yes, sir.
Right. Now, today, the topic is not lesson 1. Lesson 1, forget about this lesson. Lesson 1, employment relationship. Right. This is called what is law? Sorry. What is law? Right. What labor relations, right? What is law? Forget about this labor relations. What is law and sources of law? Okay. Right. You are studying industrial law. So therefore, it is, you have to understand, what is law and sources of law. නීතියේ මූලාශ්‍ර මොනවද කියලා අඳුර ගන්න ඕනේ. Okay? Right. Take your note. The topic is what is law and sources of law. What is law and sources of law? නීතිය කියන්නේ මොකද්ද? නීතියේ මූලාශ්‍ර මොනවාද? Ayodhya, are you taking notes?
Yes, sir.
ලුම්බිනි, සල්ලු යන නෙමෙයිනේ.
Sir?
Lumbini, do you understand?
Yes, sir.
Okay, good. The next topic is what is law and sources of law? What is law and sources of law? Suresh, is there any question? Okay. So the learning objectives of this presentation can be mentioned as follows. Suresh, you have to mute your microphone. Suresh Vijayawardana, you have to mute your microphone. Hello. Okay, right. The objectives of this presentation to make you understand what is law, to make you understand sources of law, to know about the court system in Sri Lanka, to learn about constitutional history, Vyavasthamaya, Vyavasthadayakamaya, Itihasa. Next, basic understanding about personal laws in Sri Lanka. Basic understanding about personal laws in Sri Lanka. Right. Pasindu, is it clear?
Yes, sir.
Right. Now, look at learning objectives. So you take your own note. Oh, sorry. This is it's learning objectives. Could you please take your own note by looking at the slide? Is it possible?
No, sir.
Okay, right. Then do it. Have you done?
Yes, sir.
Right. Then next subtopic. What is law? මොකක්ද අපි නීතිය කියන්නේ? You know, law is a system of rules which a particular country or community recognizes. ඒ සමාජයේ විසින් පිළිගනු ලබන rules. Right? Recognizes as regulating the action of its members. සමාජයක කොටන්කරුවන්ගේ ක්‍රියාකාරකම් පාලනය කිරීම, which it may impose by imposition of punishment. Right. What do you mean by employment law? It is a set of rules and regulations which deals with the terms and conditions of employment. Okay. Subtopic, ladies and gentlemen, what is law? There are no proper definition for law, but this is, we can't jump into another step without understand these basics. Okay. What is law? A law is a system. A law is a system of rules which a particular country, නිශ්චිත රටක්,
Sorry, sir.
a system of rules which a particular country හරිද?
Hari, sir.
Country or a community recognizes as regulating the actions of could you tell me, what we have what is law, right? Law is a system of rules which a particular country or a community recognizes. Then again, hello? Can anybody tell me what you have noted down? The last para.
Particular country or a community recognizes as regulating the actions of its
That is number 1 or 2? Hello? It is not clear to me what I said. Please, repeat the sentence. Law is the system of rules which a particular country or a community recognizes as regulating the actions of its members and which it may enforce by the imprisonment of punishment. Finish? Did you finish that?
not yet, sir.
Okay, let me tell once again. The system of rules, sorry, the law is the system of rules which system of rules which a particular country. So, can you repeat the sentence?
A law is a system of rules which a particular country
Okay.
or a community recognizes as regulating the actions of these members and which it may enforce by the
Imposition of punishment, right? Right. So, subtopic, what is law? The law is a system of, the law is a system of the law is a system of rules which a particular country which a particular country which a particular country or a community as regulating hello hello
Yes, sir.
right? What is the last sentence? Law is a system of rules which a particular country or community recognizes as regulating the actions of its members and which it may impose by the imposition of punishment. Right. Next para. The employment law, stroke labor law. The employment law, stroke labor law, stroke industrial law. law is a,
Sir,
sorry,
sir, can you tell it again?
the next para. You don't
Can
need to
you
write
tell
this.
it again?
Yeah, I'm trying to tell you again, right? The employment law, stock, labor law, stock, industrial law, is so how did we start? The employment law. How did we start? The employment law is repeat what you have written as you noted down. Employment law is what? The employment law is next para. The employment law or labor law or industrial law, any word you use, is a set of rules. A set of rules dealing with terms and conditions of employment and the protection of employment relationship. Next subtopic, ladies and gentlemen, sources of law. නීතිය මූලාශ්‍ර මොනවාද? This is very, very, very important. Very important. Right. You know, you are free to take any industrial action. Any industrial action. But if government declares a particular trade or industry as an essential industry, so could you repeat? Could you please let me know the last sentence? Hello? Last sentence. Hello? Hello, do you hear me? What is this? Kisani, can you repeat what you have, noted down? Lumbini.
Yes, sir.
So can you repeat the last sentence?
Sorry, sir. I couldn't write it.
Right? Who have taken note? Okay, forget about all these things. Number sources of law, right? This is the topic. Sources of law. Nitiya Moolas. Right. There are couple of sources of employment. Those can be mentioned or those can be highlighted. Those can be highlighted as follows. Number one, legislations or statutes. अधिकरणे हो व्यवस्थादायक. Legislations or statutes. Under this, the main sources of, this is the main sources of law. This is the main sources of law. This is the main sources of law. Full stop. Next para, eternally what command. Laws are passed by the parliament. Or legislation. Sorry.
Can you please repeat that, sir?
The main, so this is the main sources of law. Legislations or statutes, number one. Under that, this is the main sources of law. This is the main sources of law. Full stop. Law is passed by the parliament or legislature. Legislature. Under the legislature, under the previous conditions.
Sorry, sir. Under the
Previous constitutions. නිදහසට කලින් තිබුණේ 1931 ඩොනෝල් මෝල් වලට කලින් තිබුණේ කියන්නේ ඒකට කිව්වේ අපි legislature නැත්නම් රාජ්‍ය මන්ත්‍රණ සභාව, right? විවිධ නම් වලින් හැදින්නවා. ඒකට තමයි අපි legislature කියන්නේ. හරි. නිදහසට කලින්. Next para. Don't put number 2, huh? Apart from the laws, apart from the laws, laws passed by the parliament, there are other legislations called subordinate legislators. Sorry, subordinate legislations. Make a product. So you have to be very careful. Apart from the laws passed by the parliament, there are other legislations called subordinate legislations, which are named as rules. And full stop. Regulations and bylaws are passed by the various bodies under the authority of the parliament. Under the authority of parliament. Okay, number one was what? Number one was the legislation. Okay. Number one was legislations or statutes. Number two, the sources of law. Case law. Case law. Stroke. Alaira. Stroke. Court decisions. Court decisions. Within bracket, Supreme Court and Court of Appeal. Sorry, within bracket, decisions of the Supreme Court and Court of Appeal. Right. Take your note, right? Right. If there is an ambiguity,
Sir,
yes,
Supreme Court and
the Court of Appeal. The Court of Appeal. Appeal court can. Harida,
right, sir.
next para. Next para, not number 3. If there is an ambiguity, with regard to provisions of labor legislations, the higher courts interprets such ambiguities. In that context, in that context, we can say that higher courts means Supreme Court and Court of Appeal. Higher courts are interpreting the legislations passed by the parliament passed by the parliament. Hisani, do you understand what are we talking about?
Yes, sir.
So, what are we talking about right now? Okay, we are
Sources
talking.
of law.
Yes, sources of law, Nitiya Moolasva. Right? When the judges are giving judgment, they quote, they follow the judiciary process. First, they look at what legislation says. If there is ambiguity in the legislation, then they look at whether there are any previous court decisions in that regard. Then they quote that court decisions. Do you understand? Before they are giving the judgment. Rifas, is it clear?
Yes, sir.
Right. Number 3, under this of customary law. Customary law. Examples. Tesavala law, Candian law, Muslim law, those are customary laws. Number 4, textbooks and opinion of writers. Right. Just I'm asking question, but you definitely you do not know. Right. There is a very famous textbook writer in Sri Lanka with regard to employment law. Even Supreme Court is highlighting what he has said. Can anybody guess? You don't know, right? I know that. It is none other than S.R. De Silva. S.R. De Silva, former, long back ago, he was the Director General of the Employers Federation of Ceylon. He has written extensive, couple of, the quite good books. His idea has been highlighted and appreciated by the Supreme Court as well. So textbooks and opinion of writers. Number 5, not religion. Number 5. I will give you some other thing. Number 5. Opinion of the lawyers. Struck by association. Opinion of the lawyers struck by association. What do you mean by bar association? Opinion of lawyers stroke bar association. What do you mean by bar association? Is there any lawyer here? Oh. Bar association. Bar association is the lawyers association, right? They meet and, they have association, the lawyers association. They also have interpretation. Okay. Bar association. If you are a lawyer, you can become a member of bar association. Do you understand? Hello? Nobody is. Sachini? Pahadili.
Oh, sir.
So, next one, number 6, religion. Number 6, concept of equity. Number 7, sorry. Concept of equity. The 7th one, opinion of law, already we have discussed.
Excuse me, sir.
Yes. Okay.
Sir, what does mean by concept of equity?
I will let you know it later, right? Concept of equity. Sadharana bhave moola dharma, right? You will learn it. When we are dealing with employment law, the decision under the employment law, decision should be given based on just and equity principle, right? It is not a criminal law. Under the criminal law, you have to prove it beyond the reasonable doubt. Sadharana second ඔබට ඔප්පු කරන්න ඕන. හැබැයි labor law වලට එනකොට the most important concept is the equity. Sadharana bhave moola dharma. So what do we mean by equity will be discussed later under the Industrial Dispute Act. Suresh, can you satisfy?
Yes. Yeah, yes, I got it. Okay,
Right,
thank you.
right. So the court system or court structure of Sri Lanka, there are 2 slides, original courts and the appellate courts. Appellate courts means, superior, the advanced court. Previously, we had primary court, not in existence today, long back ago. Now, the original courts is the magistrate court. If there is civil case, the action is filed at the magistrate court. If there is a violation of labor law, the application is filed with the magistrate court. District court. District court is for commercial matters and district court deals with the contract of employment. I mean, it's under the common law or contract law. District court is when it comes to labor law, district court is not important. If, say, for example, you work for a company, there is an agreement between you and employer. If you want to resign, you have to give 1 month notice in advance, 1 month notice. If you do not do so, you have to pay 1 month salary. But what you will do is, you will take your monthly salary and do not report to work. In such cases, in order to recover that money, 1 month salary, the employer has to go to district court, not the magistrate court. Do you understand?
Yes, I understand.
Right. And the next highest court is original courts, commercial high courts. So, commercial high courts has dual purpose, working as the commercial high courts and the provincial appeal court. If, the appeal against the decision of the labor tribunal, arbitrator definitely should go to the commercial high courts. In that context, commercial high court act as provincial high court. What does it mean? Commercial high courts, ladies and gentlemen. Sorry. Commercial high courts is, sorry, I made a mistake. Sorry, it just, commercial high court means, dealing with commercial matters. වාණිජමය කරුණු. labor නෙමෙයි, right? මට වැරදුනා මං අනිත් පැත්ත එක මෙහාට දාලා කිව්වේ, sorry. Then appellate courts. There are 3 appellate courts: provincial high courts, court of appeal, and the Supreme Court. So, when it comes to provincial high courts, it has dual purpose, dual characters, or dual role. One is to act as provincial high court. Second is to act as civil appellate court. Civil appellate courts. If you want to go to court against the decision of a labor tribunal or an arbitrator, then you should directly go to provincial high courts. And in that context, it acts as appellate courts. That is what I'm telling. Appeal court has dual role. And then Court of Appeal and the Supreme Court. Court of Appeal and the Supreme Court. Okay. If you want to go against the decision given by the Commissioner General of Labor, or the decision given by the magistrate courts, the decisions, if you want to go against, if you want to take action against the decision given by the Commissioner General of Labor and the decisions given by the magistrate courts, then you can go directly to the Court of Appeal and then Supreme Court. But against the decision given by the labor tribunal and the arbitrator, you are not supposed to go directly to Court of Appeal. You are supposed to go to the provincial high courts. And then you can jump into Supreme Court. Do you understand? Do you want me to explain further? You are not talking of. Kisani, is it clear to you?
Yes, sir. Yes, sir.
Right. Rifas,
Yes, sir. It's clear.
Sachini, Pereira. මට ඇහෙන්නේ නැහැ දරු. Fatima, what about you?
Yes, sir. Clear.
Right. Right. So you have to take your own note. Right. Is it visible for you? Is it visible to you? Court system or structure of Sri Lanka? Court system or court structure? Is it visible?
Yes, sir.
Right. එහෙනම් මේක ලියා ගන්න. Left side and the right side. And then after taking your note, now is 9:10. I will give you 5 minutes to take your own notes in this regard. Then it becomes 9:15. Up to 9:30, you will be having a break. First, you take this note and then go for a break up to 9:30. Do you understand?
Yes, sir.
Okay, right.
Yes, sir.
Okay, let's start. We are on time. So, next subtopic is non-judicial dispute resolution bodies. This is the court system. Apart from this, we have some other bodies which deals with dispute resolution, right, in Sri Lanka. Those are Human Rights Commission, labor tribunals, rent board, mediation board, etc., etc. These are non-judicial dispute resolution bodies. So we have to remove this. This is also non-judicial, but the partial judicial. Partial judicial. Okay, right. Non-judicial dispute resolution bodies. Apart from the court, human right deals with human rights. Labor tribunal deals with termination. It's kind of a partial judicial. Rent board, there are some rent and mediation board under the Ministry of Justice, but not under the Ministry of Labor. So therefore, you don't need to write this one. Forget about this because it may confuse you. Right. Now, the subtopic is the constitutional history of Sri Lanka. Constitutional history of Sri Lanka. Subtopic, constitutional history of Sri Lanka. Constitutional history. ව්‍යවස්ථදායකමය වශයෙන් වන ඉතිහාසය මොකක්ද? What are we talking about right now, Mohammed? Mohammed, tell me. What are we dealing with right now? Ladies and gentlemen, before we discuss the labor legislations, we have to understand what is law and how labor legislations are being enacted, what are the court systems in Sri Lanka, what is the constitutional history in enacting labor legislation in Sri Lanka. Those are basic backgrounds or basic information that you must understand before we discuss the provisions of labor legislations. Is it clear or not? I'm asking you. Okay, subtopic, the constitutional history of Sri Lanka. Take your note. Before we discuss, the provisions of labor legislations, Come
Sorry,
on.
sir. The provisional.
The provisions. Could you read the sentence from the beginning?
Before we discuss the
Before we discuss the provisions of pratipadana, provisions of labor legislations, it is important to understand the constitutional history of Sri Lanka. Accordingly, accordingly, give me just 1 second. Accordingly, there are couple of aspects that we should focus as far as the constitutional history is concerned. Okay, number one, declaration of colonies, Britani Atat Vijitya, Ekda Satya Hai. Declaration of colonies. Number one. Number two, the Royal Charter of Justice in the Royal Charter of Justice in 1801, 1801, full stop. And then continue. Establishment of Supreme Court of Sri Lanka. Consisted of one principal judge, who was the Chief Justice. Okay. Asuma Aziz, are you aware of what we are talking right now?
Yes, sir.
Right, good. Right, number 3. Clauses of the Candian Convention. Clauses of the Candian Convention. Put a dash. Dash එකක් දාලා ලියන්න. The religion of Buddha. Clauses of Candian Convention. Put a dash. The religion of Buddha was declared as inviolable. Inviolable. I-N-V-I-O-L-A-B-L-E. Inviolable. And inviolable, and its rights to be maintained and protected. Then මම මේක සිංහලෙන් කියන්නම්. හැමෝටම තේරෙනවයි කියලා මං හිතනවා. බ්‍රිතාන්‍ය පාලන සමයේදී clauses of the Candian Convention කියන එක යටතේ the religion of Buddha, ඒ කියන්නේ බෞද්ධ ආගම කියන එක was declared, ප්‍රකාශයට පත් කළ as inviolable, අනුලංඝනීය, උල්ලංඝනය කළ නොහැකි අයිතියක් සහ ඒක ආරක්ෂා කළ යුතුයි, ඒක සුරක්ෂිත කළ යුතුයි කියන එක. That is what it means to be maintained and protected. Inviolable means anulanganiya, right? It cannot be violated. So even under the British colony, I'm not trying to emphasize you that Buddhism is the best, but I'm not emphasizing. I'm a kind of a non-religious man. Yes, I'm Buddhist by birth, but I respect all the religious. I know somewhat Quran and a little bit, and Bible and Tripitaka as well. So I respect all religions, but as a person, I don't have any particular religion. By birth, yes, Buddhist. Yes, Buddhist, but I don't have any particular thing. But even under the British colony, the religion of Buddha was declared as inviolable, anulanganiya, ullangane kala nohaki aitya. Do you understand what I'm trying to tell you? Kisani, is it clear?
Yes, sir.
Right. So now, I'm moving to the constitutional reforms. We are talking about the constitutional history now. So, constitutional reforms. The first reform was Colebrook, 1833. Name of the legislature was Legislative Council. The total number represented in the Legislative Council was 15. And then we had Macklem, constitution or reform. The name of the legislation was the same, but the number was 21. And then we had first Manning reform in 1920. The name of the legislature was Legislative Council. The total number of the Legislative Council representing was 37. And we had then second Manning reforms in 1921. The name of the legislature was Legislative Council. The total number representing the Legislative Council was 49. Okay. So, take your note. Is it visible?
Yes, sir.
Okay. Take your note because, I can't tell you, this first column, second column, third column. It is visible, right? You take your note. I will give you 5 minutes. Have you done? Have you finished? ඉවරද?
Yes, sir.
Right. Next one. This is the history of constitutional reforms. Then, look at the, the last second Manning reform. Then we had Donomore, 1931. The name of the legislature. Today we are talking about parliament, but at that time it was state council. Before that, legislative council. But after 1931, the council was named as state council. Rajya Mantrana Sabhav. එහෙම එකක් අහලා තියෙනවද? State council means Rajya Mantrana Sabhav. Have you heard about this? Those who have done any political science. Okay. The total number representing that state council was 61. That was the legislation. That was the body which was approving or passing the legislation. Then after 1947, it was Solbury. Then the legislative council, the name of the legislative council, right? Previously, it was legislative council and then state council, then it becomes the parliament. Parliament. 131 members. And then we had 1972, first Republic Constitution. So, in that context, the name of the legislature was named as National State Assembly, Jatika Mantrana Sabhava, Rajya Mantrana Sabhava, National Jatika, or sometimes it's called Rajya Mantrana Sabhava. The members were 151. Now today it's also again now after 78 constitution, it's a parliament. How many members? The total number of members? How many? Mohammed, how many? Now. Kisani, how many? Total number of members at present. Suresh.
225.
Kisani, how much?
225.
Yes. 225 ලෝපියව කියලා කියන්නේ ඔක තමයි. Now, the name of the legislature has again changed after 1978 Constitution as Parliament. Now, there are 225 members. Okay? You take your own note in this regard as well. This is the continuation. You don't need to write, have any other, the separate, what do you call, graph or whatever it is, right? Table. You can continue it, right? After this is the last one. Second Manning reforms, 1921, do means Legislative Council, 49. Then it was changed. Donomore, 1931, State Council. And Solbury, under Solbury, Parliament. And under 1972 Constitution, Republic, National State Assembly, Jatika Mantrana Sabha. Okay, have you done?
Yes, sir.
Right. Now, we are going to discuss some main features of the 1978 Constitution. We have 20th Amendment for this one. Forget about all these things. But, right, we have to understand what are, the main features of the Constitution of 1978. Right? So, the 1978 Constitution, the chapter 1 deals with people, state, and sovereignty. Sovereignty. Chapter 2 deals with Buddhism. Chapter 3 deals with fundamental rights. Chapter 4 deals with language rights. Chapter 5 deals with citizenship. Chapter 6 deals with directive principles of the state policy and fundamental duties. These are the fundamentals. Whether amendments comes or not, these are fundamentals, right? Still, we use the 1978 Constitution. Now, it is 20th Amendment. 21st Amendment is about to come. But amendments to what? Amendments to 1978 Constitution. After 1978, how many amendments? Almost 20. 78, right? 88, 98, 2008, 2080, and yeah, almost 43 years. During this, 44. During these 44 years, we have had 20th Amendment. 44 divided by 20, almost 2. Every 2 years, we have had amendments to the Constitution. Suresh, are you getting what I'm trying to tell you?
Yes, sir. I'm getting.
Okay, right. These are the main features before we jump. Now, after this presentation, what is our next presentation? Entirely, exclusively, the labor law. Industrial Dispute Act, termination. There are 16 acts that we are going to discuss. This is our 5th session. Once this is finished, then we just directly go to labor tribunal. This is, labor law. This is the basic or background. This provides platform for you to understand all these lessons that we have already discussed. Provide platform for you to understand very easily the provisions of the labor laws. Okay, take you or not. පේනවනේ මේක ලියා ගන්න. මම කියන්න ඕනේ නෑනේ. Do you want me to read it? Or would you like to take you or not?
Sir, no need to read it.
Okay.
Sir,
Yes.
What does mean by sovereignty?
Sovereignty. Very important. People, state, and sovereignty. Sovereignty means let me, just I'm trying to recollect the singular meaning, singular word, right? Meanwhile, I will try to recollect it. You take your note, please. Right. So it was like, I'm trying to recollect the singular word. You take your note, right? Meanwhile, I will find it out. Okay, right? It is kind of Swairitva. I don't know how to explain it. Swairitva. Tamantama තියෙනවා අනන්‍යතාවය. Have you heard about the word Swairitva?
ඔව් සර් අහලා තියෙනවා.
Ah, right. So this is what does it mean, right? So Swairitva, right? Oh. හරි ඕ මං ගත්තයි කියලා කියන්නේ ඔයා කන්න. ඔයාට කන්න නෑනේ වෙන. හරි කන්න. හරි. Have you done? Did you finish?
Yes, sir.
Right. The next one is there. Chapter 7. The executive, president, parliament or council, right? Executive, cabinet of ministers. Chapter 9. Executive public. Do you know? Right. There is the permanent executive. ස්ථාවර විධායකය කියලා එකක් තියෙනවා. Permanent executive. Who are representing that permanent executive? President is His Excellency the President. Yes, executive. Right? And then the cabinet as well. But at the same time, there is another one that is called permanent executive. ස්ථිර විධායකය. කියලා අපි සිංහලෙන් කියනවා. So what is that? So who are they? Who are they? මං ඔබට මෙහෙම කියන්නම්කෝ. ආණ්ඩුවක් විසිරුවුවත් ප්‍රෙසිඩන්ට් කෙනෙක් නැති වුණත් ඡන්දයක් පවත්වලා නැවත රජයක් බලයට පත් වෙන තෙක් රජයේ කටයුතු ගෙනියන්නේ කවුද?
භාරකාර ආණ්ඩුවක්.
නෑ, භාරකාර ආණ්ඩුවක් නැතු ආණ්ඩුව විසිරුවාට පස්සේ භාරකාර ආණ්ඩුවක් නෑ. ආණ්ඩුව විසිරුවා කියන්නේ ආණ්ඩුව විසිරලා මැතිවරණයක් තියෙනවා. මැතිවරණයකින් වෙන ජනතා ඡන්දයෙන් නව රජයක් බලයට පත් කරගන්න අතෙක් භාරකාර ආණ්ඩුවක් නැහැනේ. කවුද රජය ගෙනියන්නේ?
ස්පීකර්ද?
නෑ, පිස්සු. අමාත්‍යාංශවල ලේකම්වරුන් සහ head of the department ලා. රජයේ ආණ්ඩුව විසිරුවට පස්සේ වෙන කාටවත් බලයක් නැහැ. නැවත රජයක් පත් කරගන්නා තෙක් රජයේ කටයුතු ඒ ආකාරයෙන්ම පවත්වාගෙන යන්නේ කවුද? එන්නේ අයට තමයි කියන්නේ අපි ස්ථිර විධායකයෙක් කියලා. ඒ අමාත්‍යාංශවල ලේකම්වරු. ඒ අය තමයි බැඳිලා ඉන්නේ. ඒගොල්ලන්ට කියන වෙන නමක් තියෙනවා. මොකද්ද? They are named as Chief Accounting Officer. ප්‍රධාන ගණන් දීමේ නිලධාරියා. සියලු දේවල් වලට වග කියන්න ඕන කවුද? අමාත්‍යාංශයේ ලේකම්වරයා. අන්න ඒ අමාත්‍යාංශ ලේකම්වරුන්ගෙන් සමන්විත සහ head of the department ලට ඒ කියන්නේ තීරණ ගන්න අයට අපි කියනවා කවුරු කියලාද? ස්ථිර විධායකයෙක් කියලා. Permanent executive. President, yes, executive, but only for 5 or 6 years or 4 years. Then he may have to go. But the secretaries of the ministries, they may not go. Position, the person may change, but the position may not change. They are responsible. මං කියන එක තේරෙනවද? Do you understand what I am trying to tell you? Suresh, any doubt?
Hello.
Hello, yes. Is there any doubt?
සර් එතන දැන් අර මේ පොසිෂන් එක චේන්ජ් වෙන්නේ නැහැ කිව්වනේ. පර්සන් චේන්ජ් වුණාට
පුද්ගලයා වුණාස් වුණාට පොසිෂන් එක චේන්ජ් වෙන්නේ නැහැ. මෙහෙමයි. ඔව්. කියන්නේ
අර ප්‍රෙසිඩන්ට් චේන්ජ් වෙනකොටත් එතනත් එහෙමනේ එහෙම කියලා ගන්න බැරිද?
නෑ නෑ එහෙම ගන්න බෑ. President is elected. Elected, not selected. මේක තේරුම් ගන්න. මේ දැන් සරල විදිහට කියමුකෝ අපි. දැන් ප්‍රෙසිඩන්ට් හිටියත් ආණ්ඩුව විසිරුවට පස්සේ රජය කරන්නේ කවුද කියන්නේ?
අමාත්‍යාංශ ලේකම්වරු.
අමාත්‍යාංශ ලේකම්වරු සහ ඒ යටතේ ඉන්න head of the department ලා. නැවත රජයක් ඵලයට පත් වෙන තෙක්. දැන් ප්‍රෙසිඩන්ට් ඉලෙක්ටඩ් නේ. මහා ඡන්දයකින් තෝරගන්න බෑ. හැබැයි රජයේ නිලධාරියා ඡන්දයකින්ද තෝරගන්නේ?
නෑ.
නෑ. නෑ. එනිසා මේක තේරුම් ගන්න. මේ කියන්නේ රජයේ නිලධාරියා උසස් කොට සලකනවා කියන එක නෙමෙයි. කියන්නේ විධායකයේ සහ ස්ථාවර විධායකයේ කියලා දෙකක් තියෙනවා. ස්ථාවර විධායකයේ නියෝජනය කරන්නේ අමාත්‍යාංශ ලේකම්. මොකද සියලු දේවල් වලට වග කියන්න ඕනේ ඒගොල්ලෝ. කෝපයකට ගියාම පබ්ලික් account committee එකට ගියාම සියලු දේවල් වලට වග කියන්න ඕනේ ඒගොල්ලෝ. එහෙම අන්තිමට සද්ද නොකර හිරේ ගිය මිනිසුත් ඉන්නවා ලංකා ඉතිහාසයේ පුරා. හිරේ ගිය මිනිසුත් ඉන්නවා. right. okay anyway right. දැන් මෙතන මේ කියන එකත් පොඩ්ඩක් ලියා ගන්න. මේකත් ලියා ගන්න. just for I will give you just 2-3 minutes. Okay, well, right. So we will move to another slide. Then there are some personal laws, but we are not dealing with this one. If you want some, the clarifications or kind of explanations, I will give you later. But sorry, in this session, these are not that much important. These are personal laws. Kenyan law, Tesawalame law, and the Muslim law. Right. So, next subtopic is personal law. Personal law. There are subtopic is personal law. Right. There are 3 main personal laws. 3 main personal laws. Number 1. Kenyan law. Number 2. Tesawalame law. Tesawalame law, Tamil. Number 2, Tesavalame law. Number 3, Muslim law. These are personal laws, ladies and gentlemen. Next, put a bullet form. Next para, the first bullet form. There are two main sources of personal law. Full stop. One is statute and ordinance. Full stop. Statute and ordinance. It means law, right? The other one is case law. Other one is case law. ඒ කියන්නේ අධිකරණ වලින් දීපු නඩු තීන්දුව. Okay. Next bullet form. Just, put the bullet form. Ladies and gentlemen, the policies relating to personal law have connection with the property law. Property law, when it comes to property law, say for example, right? If you have property, so okay, 10 acres, you die. Automatically, according to property law, 50% goes to your spouse. If you are a male, 50% goes to your wife. If you are a female, 50% goes to your husband. Another 50% goes to your children. If you do not have children, that 50% goes to the parents of the principal. If parent is not there, already died, and then that half goes to the brothers and sisters. Right? Okay. Now, assumes that I'm a person, right? So work for the private sector company. I die. Then I'm entitled for gratuity and my EPF as well. I am married. My wife is there, but I don't have children. So 50% of my EPF, ETF, and gratuity goes to my wife. Another 50% goes to children. As I don't have children, that 50% goes to my parents. If I do not have parents, I mean, if they have died, that 50% goes to my brothers and sisters. That is the property law in this country. Do you understand, Suresh? Lumbini, is it clear? Kisani, Did you understand?
Yes, sir. Yes, sir. Yes.
Okay. Suresh, what about you?
Yes, sir. Yes, sir.
Okay, right. Okay. Bullet number 2. Policies relating to personal law. Policies relating to personal law. Did you take your note? The first bullet was there are two main sources of personal law. The one is statute and ordinance. The other is case law, right? You have taken your note, right? Am I correct? ඒක ලියාගත්තද පළවෙනි?
Yes. Oh, yeah, got it.
Right. Number 2, policies relating to personal law and have. Policies relating to personal law. Policies relating to personal law have connection with have connection with the property law. Property law. Right. Bullet number 3. Bullet number 3. Policies, sorry. Personal law should be prepared based on the opinion of the society. Next bullet form. Right. Most important section. Most important section of the personal law is the family. පවුල තමයි personal law එකේදී වැදගත්. Is the family. Is the family. So I mama microphone mute kala. Is there any question so far? Then so far what we have discussed, we didn't discuss any single provisions in relation to labor law. We just discussed the background. What is important for you to understand is that if there is no employer-employee relationship, whether it is written or oral or explicit or implicit, whatever it is, we can't apply the labor legislations. So then, labor laws are applicable if there is an employer-employee relationship. Employer-employee relationship in Sri Lanka does not necessarily need to be as written document. It should be oral, like implicit. Then there is a question, how do we test it? How do we prove it? There are many ways to prove it, right? Control test, integration test, economic reality test, mixed method. Those are the methods that we can use to identify whether the person X is an employer or an independent contractor. These are the knowledge that I tried to give you before I jumped into labor law. Is it clear to you or not?
Clear, sir.
Suresh, Kisani,
Clear, sir.
good, good. From next day onwards, we are going to deal with what? Labor exclusively. The provisions of labor legislation, starting from the Industrial Dispute Act. Starting from the Industrial Dispute Act. Suresh, do you hear me? What about Lumbini?
Yes, sir, I hear you.
Okay. Do you understand what I'm trying to tell you? From the so far, this is the fifth lesson. Right. We have 24 lessons. So far we discussed the basic, the background, the supportive, provisions. But from next day onwards, we will be discussing exclusively the provisions stipulated in labor legislations. There are 16 legislations that I'm going to discuss with you. Industrial Dispute Act, Trade Union Ordinance, EPF Act, ETF Act, Gratuity Act, Purchase Ordinance, Women, Young Persons and Children Act, Maternity Benefits Ordinance, and Termination of Employment of Workmen Act, the Gratuity Act, Wages Boards Ordinance, Sopanopees Employees Act, Minimum Retirement Age Act, Minimum Wage Act, 2005 Budget Relief Allowance of Workers Act, 2016 16 budgetary relief allowance of workers act. Altogether 16 acts. The provisions stipulated in those statutes will be discussed in length with practical example. But what I mean by practical examples, court decisions, Supreme Court and Court of Appeal decisions. So these subjects will be discussed with those. So, any questions open? I would like to hear you from your side. Is there any? Because we have another 15 minutes. Any question? Amsa, is it clear? Amsa
Yes, sir.
පැහැදිලිද?
Yes, sir.
Right. Lumbini,
Yes, sir, I heard it.
Kavisha,
Yes, sir.
and what about Sachini Pereira?
Yes, sir.
Harsani, no response. Okay. Right. So I have another, 50 minutes up to 11 o'clock. I'm waiting. And if you have any question, please raise. If you do not raise within 3-4 minutes, I understand you have understood everything or you didn't understand anything. Okay, tell me. So what is the real answer? Did you understand everything or you didn't understand anything? Only two answers. Okay, right. Anyway, so then shall we stop, ladies and gentlemen?
Yes, sir. Okay.
Okay. So good night for everyone. Right. We have another 10-15 minutes, 10 minutes. But if you are not raising any questions, so I will be winding up. So good night for everyone. From tomorrow, next day onwards, we will be discussing exclusively the provisions of the labor law. Okay? Right.
Yes, sir. Good night.
So good night for everyone.
Good night, sir.
Good night.
Night.
Good night, sir.
Good night.